have a.
He is. He's right behind you.
Sorry, I have a motion that I need to make outside the presence of Mr. Copeland.
All right, you can make it right now. Is he out?
Let me know when you get down to
Is Mr. Copeland out?
No, he's upstairs.
Okay, good. All right.
Yeah, come on down. Don't come in the court. We'll come and get you back.
Thank you.
Go ahead.
The way I understand my constitutional obligations pursuant to the 6th and 14th Amendments of the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told based upon information and belief that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information and belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information and belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never.
Mr. Steele, can I interrupt you for just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you a question. How did you find out about it? I'm
going to ask you the question.
Okay.
Scuttle, if you look at SCUDDER versus state, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me and you and Mr. Adams meet with me and others have met with me, it's those are ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said.
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to get anybody else.
I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have this. I have problems right now.
Okay, I know. Look, I don't want to know about your problems. Okay, at this point in time, all I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
a witness who was sworn in Friday. The court's telling. This is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it proprietary?
Or information that you should not be having that was ex parte
Why?
with a party,
Why?
state of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly
That's
this honorable court,
okay.
or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele,
I'm
I
doing
still
what
want to
everybody
know,
should
how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why,
Sir, I'm going to hold you in contempt if you don't tell me who the,
I'm not, I
tell me who this information
don't
was
want to
come
be
from.
held in contempt.
Well,
I'm not
then-
answering that question. That's attorney-client privilege information. I am not answering.
Attorney-client privilege, unless you were in my chambers, that's the only way you can figure out.
I am
I
telling
tell you what, I'm going to give you 5 minutes. If you don't tell me
you don't
who,
have to. I'm
if
going
you don't tell me who it is, I'm going to put you.
But let me-
I'm going to put you in contempt
I
because
understand.
that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information
I thought you
supposedly
answered
from
that
my
question.
chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes.
This is what I was told. Mr. Copeland, Mr. Copeland made
recess.
statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No, 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 no.
Okay, Mr. Steele, would you take the podium, please, sir? All right. All right. Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again.
And I respect that. And it gives me no joy, but as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6.
I know what the rule says, but here's the thing.
Well, let me just.
You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah. And that's why I raised it. It is that serious that we should have been there and it shouldn't have happened.
Sir, that's a whole separate issue. And that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is how did you get this information?
I understand the issue. I promise you, I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get the information?
But just listen to what I'm trying to tell you. You're threatening me with contempt.
Privilege would occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you. I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, you're asking me, I'm not saying you're ordering, but to give you information, and you're saying it's not sum and substance, but I'm telling you, I can't do that under the bar rule.
All right, well, I'm gonna hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
I can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an idea how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time. And I'm not sure.
I don't want to hold you in contempt, but this is that serious.
Judge,
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, listen, and listen, I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
from whom?
Part of it.
From whom?
Well, I'd like to get the substance first, and then we can.
Okay, well, then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
Well, then, other than if you were sitting, unless you were sitting in there with a recorder, or Miss Love or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor,
And if that person gave you that information or shared that information with you, she probably violated privilege.
well, let me tell you two things. One, I don't know how that was a privileged communication. It shouldn't have
Well,
been.
it's because she has a client she's supposed to represent.
Who are you talking
But
about?
anyways, I'm not going to have
When I got this information,
I'm not going to have any further conversation
Well-
with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside our presence. That's
All right.
really it.
He can go into custody at this point in
I
time.
think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your I'm going to deny your
Becoming-
motion. I'm going to deny your motion.
I
for
understand that you
mistrial.
spoke with a
And when-
witness outside our presence.
And whenever, yes, I had an ex parte conversation,
And-
which is
and you-
appropriate.
and you influenced the witness based on information
Oh.
belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing
Okay.
happened bad, that's fine. But you're
All right.
acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside our presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay,
Why
that's for
did we
another day.
exclude in the first place? I didn't know about this. So I
That's
raised
for
it
another
before the
day.
court.
So,
I raised it as soon as we found out about it.
well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2.
okay.
That is a material or critical part of the case, and it's an automatic
Steele,
reversal.
Mr. Steele,
But you're acting like it's
Mr. Steele,
private.
that is not that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been
All right.
sworn. You know that I'm not telling you. I'm just saying if you read I'm assuming you read it. That's what it says. And you did it
Does the
supposedly.
state wish to be heard?
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is
State
why
does.
did that happen outside our presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind
And
anything.
you can't hide behind, yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got,
Because
what I
unless you're
got-
sitting there, you're eavesdropping.
What-
So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or the a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
well,
Why aren't we
I'll
entitled to the-
that's
But isn't that the issue?
that leads to be told. But
But,
State, do you have
right
anything you wanna-
now, we don't know
Mr. Steele.
why we were excluded from that.
Mr.
And I
Steele,
want that information
stop.
because
Just
Mr.
stop.
Williams' constitutional right under
Just
the
stop.
Georgia Constitution.
just stop at this point in time, because
Article 1, Section 1,
because
paragraph
you've
12
already said that. You've already
of the
said
Georgia
that.
Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, madam,
Thank
Ms.
you.
Lowe.
And Your Honor, excuse me. And I know I said this previously,
Yes, sir.
but we are not accepting any proffer
Oh,
from
gosh,
Ms. Lowe.
okay, excuse me.
Okay. All right. Yes, ma'am.
Your Honor, I am disturbed by Mr. Steele's representations to the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained within an ex parte conversation. Not only was there an ex parte communication between that we requested as a state to be on record with the court, but there was communication made, I believe, to a person and his lawyer. I don't know that the reason that council took the podium was to address that particular issue so much as it was to try and assert an inaccurate, what he calls fact, and put it out there in the open as if it were true. But we certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive. The state read the case that Mr. Steele cited. It does not stand for the proposition he asserts that it does. And regarding further legal support for our position, we would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting gets relayed to the parties who are not privy to that. The whole purpose of the ex parte request was so that that did not happen. And we expressed on the record our concerns and our reasons for concern regarding that. We believe that without more information about how that information got relayed to the defendants, we cannot make the kind of assertion I'd be inclined to make. So before making the next set of assertions, I would need to know how that information was made privy to them, to counsels for the defendant. We did not act inappropriately or outside of the rules of professional responsibility. And if need be, we will reach out to the state bar ourselves and ask what the appropriate remedy is for everything that has happened over the last 2 days, well, the last 2 work days, because we are extremely concerned. We have observed a number of actions on the parts of a number of people that I am not comfortable stating publicly at this time, but that would appear to call for being addressed in some other way. So as to Mr. Steele's request, I guess it was for a mistrial. I'm not even certain what all that was. I think it was probably more to make inaccurate assertions on the record public to whomever was within listening shot of his voice. And we would ask that the court strike everything that he said from the time he stood up and started talking after the court asked him where it was that he obtained the information that was made privy in counsel for this court.
All right.
And regarding Rule 1.6, Your Honor, we read 1.6 as standing there. 1.6 in no way shields Mr. Steele's answer that the court requested he give. Rule 1.6 has to do with attorney-client privilege, and that is information that Mr. Steele obtained from his client regarding whatever matters. I don't know if the information was leaked to his client from someone who was in chambers, or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of Rule 1.6. If the court would allow me a moment.
All right.
regarding further appropriate remedies, Your Honor, we would ask the court for an opportunity to further look into appropriate remedies for circumstances such as this, apart from what the court has already said, because it's grave enough when information is leaked from within the court's chambers regarding a matter that has been requested as ex parte, and we would ask for the opportunity to present to the court additional appropriate remedies that we believe are available.
All right. Sure.
And Your Honor, also, unless it's Mr. Adams representing Mr. Steele in the capacity as someone who has been held in contempt, Mr. Steele just argued whatever it is that they are trying to argue based on information we believe illegally obtained
Okay.
from the court's chambers.
I represent Mr. Williams, and my statements are in regards to my representation of Mr. Williams.
All right.
He has two attorneys.
Okay, yeah, he does, but
The court now having found Mr. Steele in contempt, if the court continues in that position, that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court has engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position as Mr. Steele. I am asking for a mistrial, as he did previously, and I'm telling the court that I do not believe that we can proceed at this point based upon the information that we've received.
all right. So,
And frankly, I don't believe the state has any say in that. My statements are in regards to my representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I have exactly the same position. I also do not.
well,
believe
I asked him, so I didn't ask you.
Yeah.
So, but I'll leave it at that. Okay. What is it, Mr. Sharp?
Thank you, Your Honor. As you know, I represent Shannon Stillwell. On behalf of Shannon Stillwell, I am going to be moving for a mistrial, first and foremost. I just want to clear up a few things that have been said. Today, we were instructed to come 8:30 for a 9 o'clock start. I would not be honest with the court if I said I was here at 8:30, but I was probably here at about 8:40. About 8:40. We did not start till approximately, I'm estimating 11 o'clock. Clearly, we figured something was going on. We were given no information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark. And quite frankly, we kind of remain in the dark. I am not a false accuser, okay? I do not just willy-nilly accuse people of things. So I'm not going to throw out spurious allegations like the ones that have been thrown at me over the past couple days that are absurd. But I will say, Your Honor, what I do know is just based on what we've heard over the last 20 minutes, it appears there was a meeting that I knew nothing about that involved Your Honor, the district attorneys, and a witness who had been sworn in. My client was not given an opportunity to be present at this critical stage. This was a critical stage in this trial. That error is a foundational structural error in this case, and it is the cause for an immediate mistrial. Additionally, Your Honor, I believe that this meeting, again, I'm going to ask for the transcript and I'm going to ask for the recordings as well, should they exist. But I believe that this may have also, this meeting with a witness without us present may have made the district attorneys and or Your Honor a witness to this in this case, a material witness in this case. And finally, Your Honor, I'm going to ask for as soon as possible, I'm going to ask that these proceedings be halted until we can obtain an accurate final transcript for what occurred where none of the defendants or defense counsel were present for. And also the recordings of that meeting so we can see where we are. Again, I'm not going to sit up here and make false accusations or spurious allegations. But I do think we need to figure out what happened. We need to be in the know and not in the dark about what happened when a meeting occurs with a witness that has been sworn in. And we're not invited to the party. So those are my requests, Your Honor. I think it's necessary at this time to put a halt to these proceedings. I am moving for a mistrial. I have not waived anything. I just found out about this information. It is timely, and that's our stance, Your Honor. Thank you.
I've noted your motion for mistrial. It's denied. Okay, same thing. You want the Harvey? Okay, all right. Okay, Mr.
I'm adopting all of the same.
All right,
Good afternoon, Your Honor. Carson Matthews here on behalf of Mr. Mark Huey.
okay,
We are also adopting all the arguments that have been made.
all right, sir.
Still by Attorney Keith Adams, by Attorney Max Sharp, by Attorney Douglas Weinstein. We also are, we were here at the appropriate time. And when the court did come out, we were not made aware that there had even been an communication that was had, that was on the record, just in the point of just letting the parties know that there had been this particular meeting. I had my suspicions that that was likely what was going on, but I could not reduce that to a fact. When the court came out, the court just got started. We believe that based upon, again, ex parte, we don't have to know the substance all the time. Just the fact that there was that meeting, Your Honor, would have at least put us on some notice that there was something that was going on even beforehand. I thought that would have been the appropriate move, but nonetheless, Your Honor, I'm asking the court for mistrial. I believe that it's appropriate here under these facts and circumstances. Thank you.
All right, motion for mistrial denied. Ms. T. Williams? All right, thank you, madam. Motion's denied. Mr. Garner? Okay, so noted. All right. Okay, Mr. Steele, last time, who told you? All right, Mr. Steele's in custody. And once he clears the area, we'll go ahead and get started.
If by that point means we'll get started and resume the trial, Your Honor.
Yeah, we're gonna continue. I'm not calling nothing.
I'm not going to participate in the trial without the Steele and without.
You don't have that luxury at this point in time, sir. You don't. You don't.
Without the court addressing,
You don't have that luxury. You don't have that luxury at this point in time. You don't.
without the court addressing the issue, we believe is germane.
Sir, you all are really getting yourselves cross purposes at this point in time. Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now. Say again?
Respectfully, I will not. I cannot.
Sir, you have, well, you're gonna have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time. Sir, yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly. Sir, I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you, at this point in time, there is nothing that was given, said, whatever this morning that.
If there is any accuracy to some of the information that we.
But sir, I don't even know, your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No, it's not, sir. That's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been, and the only.
Okay, well then no, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of.
Okay, all right.
May I say one thing, Your Honor?
Yes, sir, you certainly may.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir. We're going to be in recess for the next 5 minutes. Is Mr. Adams in the hallway over there? Could you get him,
Wait.
Just hang tight, sir.
All right. Mr. Adams, let me address your first refusal to go forward. We have had plenty of circumstances in this trial where you have been lead counsel and you have done more than a yeoman's job of representing Mr. Williams. And I don't doubt that that won't continue. So you don't get to have your entire defense team here. You certainly get competent counsel, which the court finds that you are in this particular circumstance. And an appellate court will review my decision for abuse of discretion. So I'm going to direct that that you continue to represent Mr. Williams. You can consult with Mr. Steele. Any breaks or anything such as that, I'll allow you to do that and continue to do that. But Mr. Steele put himself in this particular position in terms of all these. I'm not asking him for any other, or you for any other information that might be privileged or any other conversations, but I need to know who told you, because that then drives other things the court needs to probably do. So he's the reason as to why we're here in this particular circumstance. So if you or he or want to disclose to me who told you that, I'll be more than happy to reconsider.
I know Mrs. Steele will not. I also will not. And I respect the court. I respect that the court has to do whatever it is appropriate. But I would ask that the court also respect my representation of Mr. Williams and standing for him when we believe that there's been a violation that affects his right to a fair trial. And we believe that that's the position you're in. And I would respectfully decline the court's order to continue forward.
Your Honor, may I?
Sure.
Address the court. Thank you. Your Honor, there are two things at issue here. And one of them, Your Honor, is that
Can I ask from the court how it is that the state has any position in this particular conversation between the court and myself?
Before we recessed, Ms. Love said that she was going to research this ethical issue because it is an ethical one. So just much like you could add to it, I'm asking the state if they wish to add to that as well, sir. Okay?
Thank you, Your Honor. Your Honor, we believe that there are two matters at issue here. One, obviously, is Mr. Williams' right to counsel of his choice during the trial of the case. We believe that the court has the discretion to fashion any remedy, any punitive remedy for contempt that it chooses. We would ask that the court fashion a punishment for the contempt that affords Mr. Williams the right during these proceedings while court is in session to both counsel for both of his counsels. For Mr. Steele to be present in the courtroom, he can still be held in contempt. But for Mr. Williams to have representation of both Mr. Steele and Mr. Adams while court is in session, and that the court's remedy does not affect his ability to have his counsel of choice represent him during this trial. We believe that it will need that so far this issue alone has needlessly delayed the trial of the case, and we believe that it may be in someone's best interest and in others not in their best interest for that delay to continue. So we would ask that the court, notwithstanding the finding of contempt, allow both Mr. Williams, Mr. Steele, and Mr. Adams to be present while these proceedings are going on and while court is in session.
I think that would be appropriate under the circumstances. And Mr. Steele, certainly I can inquire about before the end of the day if he wishes to disclose that information that I've asked him, then he certainly purges himself of that contempt. So yes, that's fine. We'll go ahead and do that.
And the second thing that I wanted to put on the record is that there was no substantive communication with any witness in this case outside the presence of any counsel for the defendants or any defendants in this courtroom. The matter, Your Honor, if I may finish, the matter that the state requested an ex parte audience with the court regarding was a matter to which no one to my right was a party. It was a civil contempt matter, and the parties towards that civil contempt, the state, which moved the court to compel someone to do a thing, the court compelled, and the state said, Your Honor, we're asking if the court, if they don't comply, that the court hold that person in contempt. That was a civil contempt matter. Nothing substantive was discussed. Everything was recorded, and the representations made, at least by persons who were present to the state, is that when questioned or queried about it, is that that person was told or asked whether things occurred, and that that person relayed that no substantive communication took place during that meeting. So that is the second matter. And first and foremost, we just ask that the court again allow both counsels for Mr. Williams to be present when court is in session so that we don't delay these proceedings further.
All right, that's fair enough.
Thank you.
Okay,
Your Honor,
Mr. Sharp?
the ability for the state to paint themselves as the victim constantly in these matters is unbelievable. We are the aggrieved party.
Sir, we can't hear you.
My client, Shannon Stillwell, and these other young men sitting here as defendants are the aggrieved parties. We were not present. I would like to reiterate.
But here's the problem. Here's the
Your Honor,
challenge,
can I just-
Mr. Sharp. Here's the challenge. You got the information in a way that was not lawful to begin with, sir. That doesn't alleviate the information or make it less valid or invalid. So because we record these conversations so that they can be reviewed later. We didn't have any conversations that were not recorded. And if you heard of other conversations that were made, I don't know how you would have gotten them otherwise, because somebody had to tell you.
Okay, well, all that's.
And like I said,
This is what I know.
if and when the case gets reviewed, an appellate court will make those decisions. But at this point,
My client is the aggrieved party. He was not present. If that violated his Sixth Amendment right to be present.
okay, and that's your argument, sir. That's your argument. That's your argument.
One other thing, Your Honor.
That's your argument.
All I'm asking for is some sunlight to come over these proceedings.
Sir, this is not an open meeting. This is not sun. This is not a sunlight situation.
Release the transcript and then we can see, because we do not accept Ms. Love's representation.
Okay, you don't accept the court's representation? I'm telling you.
Like the transcript.
I'm telling you at this point in time, when the case is reviewed on appeal, if I am wrong, then certainly the appellate court can tell me, and certainly there are other bodies in Georgia that certainly my conduct can be reviewed by. But at this point, I'm telling you that's the sum and substance of it.
We are trying this case right now to win this case. We are not playing for an appeal. We would like a fair shot at this case right now. We would like the transcripts. We all know that the appellate process in this case is probably going to take decades.
Okay, well,
So
at this point, I'm, like I said, I need to have a little bit more information in order for me to kind of make some other decisions in this case. I'm not saying that you may or may not get that information, but at this point, there was nothing that was improper about in the ex parte conversations. The court's more concerned about is the disclosure. So, and
I understand the court's concern, but as the counsel for Mr. Stillwell, my concern is the meeting that he was not allowed to be present for.
okay, all right. Thank you, sir. Are you going to repeat the same thing again? Oh, let's try not to, because The Harvey rule's in effect. I understand everyone's opinion at this point in time.
And Judge, the only thing I want to say, and to not be repetitive, but on Friday, Your Honor, this particular witness came in, he pled the fifth, his lawyer was present, his lawyer stated to Your Honor that he had spoken to his witness, his client, and he stated that the witness indicated that on Monday, he will also be saying that he will plead the fifth. And then, Your Honor, there was a 2-3 hour span this morning, and then he comes on and he says, I'm going to testify. That's why I believe in the application Huey that the transcript is important.
Okay. Thank you, sir. All right. Let's get Mr. Steele out, please. You can tell him to put his tie back on. And then we'll go ahead and get started at that point in time, okay? But I'm not at this point in time going to release any of the transcript in terms of what may be disclosed or that was said in Chambers ex parte at this point.
Well, I was told based upon information and belief that it would affect this witness's testimony in front of the jury, because I was told based upon information and belief that depending upon how the day goes, he may go home or not, depending upon his testimony. I'd like to know what that's about.
I don't know, Mr. Steele. I don't know. I mean, that's why I would like to know who it is that told you or disclosed this information from Chambers, because I don't know if this person even had, if that conversation was even had within my presence or hearing. I don't.
So I would like to have a hearing with the court as a witness, with the DAs as a witness, with the deputies as a witness, with Mr. Copeland as a witness, with his counsel as a witness, court reporter, transcript. And Judge, I'm not trying to be harmful.
Mr. Steele, I think that you're running a very thin professional responsibility line. I don't think you have cover at this point in time. I think you're blowing your coverage at this point, because I do think that somebody told you some things that violate privilege.
What privilege?
Attorney-client privilege. So, I mean, but that's beside the point at this point in time. We're not going to argue about that right now. I just need the way you purge your contempt is that you just tell me who told you this. I'm not asking you what was said. But you're indicating what was said. I want to know who told it to you.
And I'm making it based upon information.
But I need to know who it is, because that's critical for the court taking remedial steps at this point in time.
You're holding holding me in contempt.
No. Yeah, I'm holding you in contempt because you won't tell me who.
How could something, I'm not trying to be obstruction, but how could something be attorney-client privilege if it happened before the court?
Well, because if somebody's a represented party and they disclose the information that to you all as parties in this case, that could be a problem. That could be a problem.
I don't,
I mean, like I said, I don't know what was said to you. I don't.
this is, I'm trying to get out. What was
Well, so, that's improper at this point in time.
Why?
Because you are telling the court conversations that you are privy to in my chambers that I know you weren't present.
But the court was present. That's what I'm trying to say.
That doesn't make a difference, but you got information that you shouldn't have had. And then you can't, and then you turn around and you say, well, I did something, the court did something wrong and that we should be entitled to have the transcript. You all have contorted and perverted that particular process. You really have.
What I said was it is a material part of the trial.
It's not, well,
Has a right to be at, and I'd like to exercise.
It would be just like if you all in the past have had ex parte conversations with the court. And I won't say about for what. You and Mr. Adams and others. That is your right. And that little period or that little conclave of discussion with the court protects you and protects the system. It's recorded and taken down. So if it needs to be reviewed later, it gets reviewed. But you have made something out of it that where I'm kind of at a disadvantage at this point in time. So because I didn't invite you into that particular proceeding, and I don't think you had the right to be there.
Well, all I know is what I told you, and there's more.
Okay. Well,
there's a witness testifying who met with the court and the DAs. That doesn't concern us,
Your Honor,
meaning the defense.
I think that for an ex parte conversation, in terms of what was said, and I'm not gonna keep continuing to discuss this because the transcript is what the transcript is, and it will say what it reflects. It really will, and the court will stand by that. But the other conversations that you may be privy to or may have been disclosed to you, they're troubling. They are. That's why I've got to find out who it is that disclosed that information. So you have the keys to your own contempt. I don't want to hold you in contempt, sir. I don't. I'm not asking you to tell me what was said between the two of you, but I do need to know who told you. So if you're willing to tell me that, that's fine. That will purge your contempt. If you don't want to, then, I'll unfortunately have to look at and waiting to get that information. So you can let me know.
Did the court put this in order?
In terms of what, sir?
I suppose contempt.
Yeah.
It's criminal contempt. It's sua sponte criminal contempt, sir. You don't get to appeal from this. You will go into custody at 5 o'clock today or whenever we finish if you don't tell me what that is. Tell me who that is. This is criminal contempt. I have asked you a question related to this particular proceedings, and if you don't tell me, then you'll suffer the consequences of that. Unfortunately, like I said, I'm not looking to hold you in contempt. I really am. I'm not. But this is that important.
Important is important.
Okay. All right. So you got to think about it. All right.
And can I just, last thing, going forward is over objection, because I believe that we're entitled to these information, especially with this witness.
All right, sir. I'll note your objection. It'll be a continuing objection for the time being. And I may make some other remedies depending upon what information I find later. Okay? All right.
On behalf of Mr. Stillwell, I'm going to review our Brady demand for any Brady material
Yes, sir.
that came out from any conversations with Mr. Copeland, between Mr. Copeland and the district
Yes, sir.
attorney's office this morning.
All right. Summon our jurors, please. Yeah, bring him out, please.